Well, last Monday, Rauf Olanio was impeached as the deputy governor of Oyo State over allegations of misconduct. The decision was reached after the Oyo State House of Assembly presented and considered the recommendation of the 7-man panel set up by Chief Judge Munta Abimbola to investigate the deputy governor for alleged gross misconduct and abuse of office. However, the impeached deputy governor has faulted the process, culminating in his removal from office.
He said that his removal was in a breach of Section 188E of the 1999 Constitution as amended, arguing that the Chief Judge of the state was wrong to have constituted the 7-man panel which recommended his removal from office. In a statement by his lawyer, Afolabi Fashanu, senior advocate of Nigeria, Olanio said the panel set up to investigate the allegations raised against him did the lawmakers' bidding. We have joining us now virtually from Abeokuta, the Ogun State capital, the senior advocate of Nigeria, Afolabi Fashanu, who is the counsel to the former deputy governor, Rauf Olanio. Yes, thanks very much, Ayo. You want to tell us the inconsistency in the removal of your client, Rauf Olanio, as the deputy governor of Oyo State, because the allegations were clear-cut to say, insubordination and, other allegations against him for his removal.
Whenever a notice of impeachment is to be served, the notice of allegation must contain detailed particulars, emphasis on detail. So when you say somebody is guilty of misconduct, that term is so wide to include so many things. You have to be specific. What type of misconduct? Did he abscond from duties? Did he disobey the governor? Did he flout the rules? That's why the law says you must give detailed particulars. For example, they were talking of, embezzlement. How much did he embezzle? Are you following me?
Well, with you.
Then who made the report of embezzlement? So all this must be contained in the notice of allegation so that the deputy governor would be in a good position to answer the allegation. As it is, all the allegations were in the air that you cannot start as an guess as to what they actually wanted. That's why we wrote them and said, oh, gentlemen, please, can you be more specific? So when they did not do that, we went to court to challenge the notice. Well, the court in its wisdom felt that there was substantial compliance. Substantial compliance. The law does not say substantial compliance. It's absolute compliance. So that is a subject of another discussion, on appeal. So taking it further, I think the aspect that will interest you on this occasion is that less than an hour after the judgment was delivered, we filed a notice of appeal coupled with application for injunction pending appeal. This is the crux of the matter.
Right. Well, the crux of the matter, you say, and I do know that you have actually applied for a restraining order on the House to not remove your client. But of course, we've seen that that has been done already because, we now have a new deputy governor in Oyo State pending the judgment of the court. But the question is, what constitutional provisions, in your opinion, were not adhered to by the committee, which you faulted even before they come up with, the resolutions that they came up with? What constitutional provisions do you think were broken, and what are the options now available to your client now that he has been replaced?
Yes, we have so many options. So many options are available to us. Don't forget that there is a pending appeal challenging the decision of the court. That one is still there. Additionally, we looked at the issues critically. We discovered that at the time the panel was constituted, there was already a lis pendis. Lis pendis means subject of litigation that nobody must tamper with, which the chief judge has done. So it's going to form part of another fresh action, which we, as I'm talking to you, have constituted that action. It's just for me to file it. We also challenge the mode. You know, the Constitution makes it clear that there are certain things that I cannot say here because we are going to let the cat out of the bag. That is the subject of new action. I don't want you to preempt me on them. But suffice it to say that we are constituting another action and it will be filed latest by Wednesday.
Well, thank you, this Honorable Silk. It's obvious that the certain political, context there between Governor Makinde of your state and your client and the rest, and you couldn't reach a political situation. The exigency of the matter, don't you think can still be politically resolved instead of, legally?
No, I think once impeachment is carried out, it is a process that has been completed and concluded. That process cannot be set aside except by a court of law. Even if all the members of their leaders, even if they meet to say, oh, we are going to have done all that we did, it is no longer possible for that process to be set aside politically, except by another of course. You know, this impeachment is not new. It happens here and there. Ladoja issue took place in 1995. I was part of the lead counsel. Fayoshe also, I was the lead counsel. So this will probably be the third of us in which I took active participation from impeachment up to Supreme Court. So we are ready for the game. We can assure you that the deputy governor will be restored.
Right. Well, you're not new to this, and a reason why a lot of people are actually, surprised that you're pushing this, because at the end of the day, if you look at since, especially the Fourth Republic, once a deputy governor actually decamps to a different party, which is exactly what your principal has done. He has left the PDP and joined the ruling All Progressives Congress. This is not unexpected, really. But as we get ready to wrap up this conversation, do you, in your honest opinion, believe that your client wasn't given a fair hearing to be able to really, speak for himself, especially on the allegations leveled against him, from insubordination to gross misconduct to even financial recklessness? Was he given a fair hearing?
Now, let me tell you this. After we had filed our notice of appeal and stay of execution, I did a letter to the chief judge telling his lordship that he, as number one in the judiciary, he should not take any action that will render the appeal nullity. So in the evening of that day, he constituted the panel. On Friday, my client was served with a notice of invitation at 9:45 a.m., asking him to come and testify at 10 a.m. the same day, which was impracticable. The following day, I did a letter telling the committee that we needed time to prepare our defense. They rejected that letter. And that was Saturday. If you see the speed at which they acted from the time the judgment was delivered, then when the deputy governor was impeached. So on that Saturday, they sat. We wrote them on Saturday because it was served on Friday. We wrote them on Saturday. On Saturday, they rejected our letter. Then that Saturday evening, they rounded up. What type of investigation are we talking about? Don't you think that it's like when before the exam, they gave you an answer. So you are working to the answer. You are working to the answer. So on that Saturday, they finished their sitting. Monday, the House of Assembly sat and then carried out the impeachment. What will you, in the circumstance or in circumstances, say Deputy Governor was given fair hearing? The Constitution makes it clear that even an accused must be given reasonable time to make his defense, to prepare his defense.
All right.
So he was served.
All right,
Yeah, he
Senior
was
Sil.
invited on Saturday. Yes.
Yeah, very well said. We want you to anchor there so that we allow the courts to do the fireworks and see if your client would have a say. I mean, he would surely will have a say in court and the judgment of the court, or vice versa. Thank you very much, Afolabi Fashanu, the SAN, the counsel to the impeached Deputy Governor for your state, Rauf Olanio, for coming on Newsnight. Thanks very much.
Thank you very much.